Paul, you served on the Land and Environment Court as judge for a good decade.
Yeah, 12 and a half years, I think it was, yeah.
And what I'd be interested to talk to you about was probably what you're best remembered for, which is sometimes called, for short, the Leach decision. And in that particular case, you became very well known for properly enunciating what's known in the environment movement as the precautionary principle. Or rather, what you did was to put in place a series of steps that you believe the precautionary principle should represent. Would you like to talk a little bit about that case? Because it was very much part of the ecologically sustainable development movement that was burgeoning in the late 80s, early 90s as a result of the Brundtland report, which came out in 1987.
Well, a lot of the early ESD principles, including the precautionary principle, had started to find their way into New South Wales legislation, particularly the environmental legislation too. But it was clear to me that sustainable development was the way to go for the future. But these principles were often complex in their wording and difficult for practical application. And I saw the task of the court, when it was appropriate in a particular case, to try to enunciate how these principles could be applied in practical situations. And the Leach case was, as you said, concerned the precautionary principle. That is a somewhat complicated principle which is difficult to apply in certain situations, and I tried to lay down some ways and means by which it could be applied in practical settings. And that was the Leach case.
When you say setting out those ways, when we talk about the precautionary principle, that is when, I suppose if you wanted to sum it up, it's when you're concerned that something may happen to, say, a species, but you don't know for sure. So the activities of, say, a developer on, say, a piece of natural environment, there's no definite proof that what they do may harm a particular species, but there is concern raised nevertheless. And so the idea of the precautionary principle is that you, as it were, proceed with caution.
Proceed with caution in the absence of scientific material. In other words, you shouldn't just go forth into the dark, but caution should be the motif that you follow. In the Leach case, there were two species. One was the giant burrowing frog, and one was the yellow-bellied glider. It was an interesting case because it was a third-party appeal, which were permitted at the time, of a conservation group in the Nowra area. Mrs. Leach was the president, I think. And it was against National Parks and Wildlife, who had given permission to Shoalhaven Council to put a road through some bushland, which was the habitat of these critters, amongst others. Interestingly enough, right in the way in the road, in the middle of the road, was a plant that was found nowhere else in the world except in this area, and it wasn't protected under New South Wales legislation. It was under Commonwealth legislation, but this was a New South Wales case. Brian Preston was the counsel for the National Parks and Wildlife, and he was obviously interested in seeing the precautionary principle established as a matter of law in any event. And so he played a sort of double-edged role, a double-edged sword role in the proceedings, and in his submission said it was an appropriate case for the application of the precautionary principle. So that made it a lot easier for me to apply the principle. But what I was trying to do in that case, which has been criticised by some ever since, is say that we should have that the precautionary principle is really a matter of common sense, that you don't act in the absence of scientific evidence, that you take a cautionary approach in those circumstances. And I was really trying to make people not so scared of the precautionary principle and principles of ESD generally, and to explain it in layman's terms. To the extent that I was successful, I don't know, but certainly ESD principles have been well and truly established by today.
Brian Preston, of course, went on to become the Chief Judge of the Land and Environment Court of New South Wales. That's right. And he paid tribute to you in this paper that I'm looking at here, Jurisprudence on Ecologically Sustainable Development, Paul Stein's Contribution. Now, he actually mentions that, I don't think it's exactly a criticism, but he did say that things did get watered down into the common sense principle as opposed to the actual precautionary principle. Now, what does he mean by that in your view?
I think he means that a strict interpretation of the precautionary principle was lost by reason of some of the things that I said and subsequent decisions said. But he's in a position to put that straight now, and I'm sure he has.
So the thing that you were saying, you were trying to bring some steps that wouldn't frighten the horses, as it were, of the public. Were you thinking also, though, that the trouble with this, and it has never really changed, I suppose, because we're looking at this very issue now with climate change, and I imagine that would have been a hairy one for you to grapple with had you been asked to pronounce on this particular issue that's occupying our minds. You've heard of the expression the boiled frog principle. Well, the boiled frog it's often invoked by conservationists that when you drop a live frog into boiling water, it'll immediately leap out, perceiving the danger. But if you put a frog in cold water and slowly bring it to the boil, the frog eventually dies. And what they're saying with that kind of situation is that sometimes people don't notice the very things that are going on around them. Trying to bring these matters to their attention, even if it doesn't seem apparent, is the biggest challenge of all. Were you, even if you didn't know that particular quote, were you in a sense mindful of the concerns there and saying, well, here is how we need to go about measuring what is happening to us, the frog?
I think so. I was concerned that there was a misunderstanding of ESD principles and sustainability generally by government and developers, and that if they weren't, as it were, settled down and live within the paradigm of sustainable development, that we'd lose it from the legislation. And we haven't, so that's something. And certainly sustainable development has become almost embedded in our law now. And I know from my work today with local governments that they do take note of sustainable ESD issues and try to apply them in their everyday working lives.
Were any of your fellow judges on the Land and Environment Court equally cognisant of these questions and issues, and to the extent that you were?
I don't think they were as wholly enthusiastic about them as I was in those days, and they had a somewhat more conservative outlook in relation to it, but they all made their contributions because ESD was in various forms of legislation, and it was there to stay, and so they had to help to interpret it.
Do you think, in a way, what has happened now, because of your interest and involvement too with local government and planning, do you think what has changed between now and then, that this 20-odd years, is that people are now viewing the environment, the natural environment, as more of a commons than perhaps they might have then? As when I say a commons, we're talking about an area or a space, if you like, with agreed, shared rules of use.
I don't know that we've become that sophisticated as a society. Certainly agree with a lot of what the Commons movement has to say. And I think that it certainly makes the point that the environment is for everyone to share and balance rather than for a few to enjoy.
Yes, because there's an interesting point here in this talk by Brian Preston, where he was mentioning that he says here public participation and access to information are relevant to the concept of ESD, although in particular cases that you were involved in, that ESD was not raised as an issue. What I'm interested to know is that you spoke also, and I think you were instrumental in bringing this about, you spoke of the importance of having environmental impact statements made as part of assessing what you do next in a particular area. So, in other words, I suppose you were giving a kind of grounding to the whole practice of looking into whether we conserve an area or what we do about it.
I don't know. I mean, EISs have been part of the system since 1980. They didn't always apply. You had a pretty tough hurdle to get over to have to do an environmental impact statement, and otherwise you do a much lesser investigation into the environment. I certainly was a supporter of proper environmental impact assessments and tried to do whatever I could do in various cases that I determined that came before me to promote the idea of balanced environmental assessments.
I'm looking at a quote here that says, "Those who philosophise on the judicial process have pointed out that it is not merely a scientific fact-finding mission where you proceed by pure logic to an answer which is definitely the right answer. Sociologists and philosophers of the judicial process point out that there are probably many answers to a given problem that can be given within the framework of law and logic. Law and logic by themselves cannot necessarily lead you to the right answer." Were you always thinking during those years about how there may well indeed be more than one alternative solution to a particular knotty question, say, to do with development?
I think so. That was a phrase from a judgment or a speech by Judge Weera-Mantri, who I know very well, or I did, who's a wonderful person. And I think that he's encapsulated it very well, and certainly it would be a view that I would agree with.
But how many judges think like that? I mean, you obviously have, because he goes on to say here, there are many factors, sociology, history, custom, the mores of the community, which the judge does use in order to make those judgments which would be in the best interests of society. Now, it's often said that judges do aim to do that, but do they always, as a matter of practice, do that? What I'm getting at, in other words, is the notion of judicial reasoning laid bare.
Well, I don't think they all do, because people are different and have different views about the law. And of course, as you know, there's a very definite schism in the law today about strict legalism and activist judges. I don't agree that there should be such a division. I think it's an anachronism to try to say there is. But if I had to put myself in one lot or the other, then I'd come out in relation to activism. But I think that activism has been much misunderstood and discredited by some pure legalists. And in my farewell speech at the Court of Appeal, I defended the High Court, in particular Chief Justice Mason and Gerard Brennan, in relation to attacks upon their decisions as being activist interpretations of the Constitution, which they weren't.
So when you talk about the misinformation on which the critics are relying, critics of judicial activism, what is the chief furphy, as you see it, of their argument, the repository of where all the misinformation actually springs from?
Oh, I think one of the things that some of those critics say is that you've got to follow a strict legalistic line, and you mustn't overturn precedent, even if it happens to be wrong. But then you find, in fact, from judgments of people that say this, that they don't follow that line themselves anyway. So I think that there's a shred of dishonesty in that intellectual approach, which doesn't recognise the realistic fact of life.
You expanded on this in the number of papers and articles you've written?
Not to a great extent. Most of my articles have been about environmental law or about other branches of law. But I did have something to say, as I said a few moments ago in my farewell speech in the Court of Appeal.